The parties entered into a legally binding contractual relationship with each other, and this arbitrator finds that there is no fraud and or any attempt to induce fraud and or to commit fraud and or inducement of contract and or fraud in the factum respecting the instant matter and contract. Thus, the parties are bound by the terms and obligations agreed upon and imposed upon them as a direct result of the contractual agreement. And this arbitrator finds that all the elements that form a contractual agreement and a legally commercial binding obligatory relationship are present. And the contract clearly expresses the method of settlement and resolution of all disputes arising thereunder shall be settled by arbitration under the authority of the standards of common law arbitration. The Federal Arbitration Act and further stipulated and appointed this arbitrator listed herein as agreed upon as the arbitrator of record. Neither party has objected, protested, and or attempted to amend any portion and or provision at any time of the contract. The contract status that all finding and binding arbitration awards may be confirmed by any court in America having original jurisdiction pursuant to Title 9, United States Code, Section 9 and Section 13. And it has been alleged and thoroughly proven that the respondents listed above have by their own accord agreed to all the terms of the contract, that they have committed the offenses claimed in the contract and have acted against the interests of the claimants, depriving them of their right to property, their right to contract, the right to pursuit of happiness, and the enjoyment of life. They have admitted and agreed that they have violated the claimant's constitutional and common law rights, that they had intentionally, knowingly, and deliberately failed to perform as agreed, and forsook their obligatory duty of care and thus created a dispute that requires a resolution by this specific arbitration association hereinafter and or any subsequent award, and the parties stipulated and agreed that the related matters, including any judgments associated thereto, any claims and any collateral tax by the respondents are null and void of any effect and shall not be binding on the claimant retroactively and henceforth. And the contract stated that the punitive damages can be optionally assessed. However, the contract remains silent as to any case that would direct the arbitrator to direct a formula to determine punitive damages. It is deemed that punitive damages may be warranted if the respondents do not voluntarily comply with this award. In such an event, this arbitrator may impose punitive damage at a rate of 3 times the amount of the actual damages in addition to other remedies and awarded. To other remedies awarded. The parties did have a prior relationship, and the respondents had an obligation to respond to the reasonable request of the claimant. One of those requests being that the respondents provide an accounting and that such an accounting be truthful and certified as being wholly accurate. As a custodian of record, a position for which the respondents volunteered, accepted such responsibility, and have yet to rebut such a presumption, this arbitrator finds that they were duty-bound and have breached their fiduciary duty of care, supporting their willful and intentional, as well as deliberate default, respecting the irrevocable binding contractual agreement that is coupled with interests. And, further, this arbitrator finds that the contractual agreement does highlight and note a settlement offer whereby the parties stipulate within the body and framework of the agreement, contract, in line with the Tucker Act, and have agreed to certain and specific terms under and in line with the contractual agreement, and there is complete diversity of citizenship between the parties, and the amount of controversy exceeds the sum of $75,000, exclusive of interest, costs, fees, and assessments, and that the venue is proper in any court of original jurisdiction wherein either the arbitrator resides or chosen by the claimant as stipulated in the contractual agreement, and that any orders compelling witness attendance, provisional remedies, equitable relief, interim awards are to be issued and enforced according to the terms of the contract as stipulated in the agreement, and that the parties have agreed that all pre-existing as well as existing contractual agreements between the parties, no matter their scope, subject matter, and or detail, are superseded and extinguished by the contractual agreement referenced and related hereto. And should the claimant elect that jurisdiction for the final award may be had under the Tucker Act in the United States Court of Federal Claims as the exclusive jurisdiction for said court of claims for damages against the United States under contract in excess of $10,000, since this matter is against an institution registered and licensed with the United States, during the time of its conduct is construed as one and the same as a matter of law. The Federal Court of Claims would be at the election of the claimant, a chosen proper jurisdiction to have the matter determined under common law and or as stipulated in the contract at any court of original jurisdiction. Basis for arbitration. On or about May 2nd, 2019, the claimant and the respondents entered into a written, self-executing, binding, irrevocable contractual agreement coupled with interest for the complete resolution of their misconvictions and other conflicts respecting their previous relationship. The respondents made an attempt to change the terms of their contractual agreement, and the claimant presented a counteroffer or conditional acceptance of the offer to the respondents. The record clearly documents that the respondents have failed to properly respond after they received the counteroffer. Whereby such non-response would equate to tacit acquiescence, thereby creating an estoppel respecting the respondents and any future claims and or prior claims and or present claims associated with this instant matter. It appears that a dispute has arisen on the agreement between the parties, and it is the subject matter at bar. The claimant contends that after agreeing to the terms of the contract, the respondents have failed to fully perform to the terms of the agreement, and that the claimant is entitled to immediate and unconditional remedy as prescribed within the terms of the contractual agreement. The claimant has demanded liquidation of the estate trust, and the respondents have failed to act. The contractual agreement stipulates that the arbitrator may adjust the amount of the award to exclude fees, adjustments, costs, and other expenses. The contractual agreement provided for arbitration of disputes at a specific arbitration association, which stated in relevant part that the arbitration process is binding on all parties and is the sole and exclusive remedy for redressing any issue associated with this agreement, that this agreement supersedes and predates as well as replaces any and all prior agreements between the parties and is binding on all parties and irrevocable. And the parties agreed to the terms and conditions of this agreement upon default of the defaulting party as of the date of the default. Arbitration and administrative remedy cognizable at common law. Additionally, it is exigent and of consequence for the claimant to inform respondents in accordance with the pursuant to the principles and doctrines of clean hands and good faith, that by respondent's failure or refusal to respond and provide the requested and necessary proof of claims, it shall be held and noted and agreed to by all parties, that a general response, a non-specific response, or a failure to respond with specificities and facts and conclusions of common law and or to provide the requested information and documentation that is necessary and in support of the agreement shall constitute a failure and a deliberate and intentional refusal to respond, and as a result thereby and or therein expressing the defaulting party's consent and agreement to said facts, and as a result of the self-executing agreement, the following is contingent upon their failure to respond in good faith, with specificity, with facts and conclusions of common law to each and every avertment, condition, and or claim raised, as they operate in favor of the claimant through tacit acquiescence. Respondents not only expressly affirm the truth and validity of said facts set, established, and agreed upon between the parties of the conditional acceptance, and respondents have agreed and consented to respondents having a duty and obligation to provide the requested and necessary proof of claims, which will create and establish for respondents an estoppel in this matter, and all matters relating hereto and arising necessarily therefrom. And in accordance with and pursuant to this agreement, a contractual consensual binding agreement between the parties to the conditional acceptance for value to include the corporate government agency department constructs whom respondents represents, serves, as well as all officers, agents, employees, assigns, and the like in service to respondents, will not argue, controvert, oppose, or otherwise protest any of the facts already agreed upon by the parties said and established herein, and necessarily and of consequence arising therefrom, in any future remedial proceedings, actions, including binding arbitration and confirmation of the award in the District Court of the United States, at any competent court under original jurisdiction in accordance with the general principles of non-statutory arbitration, wherein the conditional acceptance, contract number, constitutes an agreement of all interested parties in the event of default and acceptance through silence, failure to respond, when a request for summary disposition of any claims or particular issue may be requested and decided by the arbitrator. Whereas a designated arbitrator was chosen at random, who is duly authorized, and in the event of any physical or mental incapacity to act as arbitrator, the claimant retained the authority to select any neutral arbitrators that qualify pursuant to the common law right to arbitration. As the arbitration process is a private remedy, decided upon between the parties and with respect to this contractual agreement, the defaulting party waives any and all rights, services, notices, and consents to the claimant and or the claimant's representative selection of the arbitrator, thereby constituting agreement, and any controversy or claim arising out of or relating in any way to this agreement or with regard to its formation, interpretation, or breach, and any issues of substantive or procedural arbitrability shall be settled by arbitration, and the arbitrator may here decide the controversy upon evidence produced, although a party who was duly notified of the arbitration proceeding did not appear, that the claimant deems necessary to enforce the good faith of all parties hereto within, without respect to venue, jurisdiction, law, and forum, the claimant deems appropriate. An arbitrator's award should not be vacated for errors of law and fact committed by the arbitrator, and the court should not attempt to mold the award to conform to their sense of justice. Further, respondents agree that the claimant can secure damages via financial lien on assets, properties held by them, or on their behalf for all injuries sustained and inflicted upon the claimant for the more wrongs committed against the claimant as set, established, agreed, and consented to herein by the parties hereto, to include, but not limited to, constitutional, impermissible misapplication of statutes, laws, and the above referenced alleged commercial civic cause, fraud, conspiracy, two or more involved, trespass of title, property, and the like, and all other known and unknown trespasses and moral wrongs committed or ultra-virus acts of all involved herein, whether by commission or omission. Final amount of damages to be calculated prior to submission of this tort claim and or the filing of a lien and the perfection of a security interest via a uniform commercial code financing one statement, estimated in excess of $10 million USD or other lawful money or currency generally accepted with or by the financial markets in America, and notice to respondents by invoice. Per respondent's failure and a refusal to provide the requested and necessary proof of claims, and thereby and therein consenting and agreeing to all the facts set, established, and agreed upon between the parties hereto, shall constitute a self-executing, binding, irrevocable, durable general power of attorney, coupled with interest. This conditional acceptance for value and counteroffer claim for proof of claim becomes the security agreement under commercial law, whereby only the non-defaulting party becomes the secured party, the holder in due course, the creditor in and at commerce. It is deemed and shall always and forever be held that the claimant and all property, interests, assets, estates, trusts, commercial or otherwise, shall be deemed consumer and household goods not for profit and or gain, private property, and exempt, not for commercial use, non-taxable as defined by the UCC Article 9, Section 102 and Article 9, Section 109, and shall not in any point and or manner past, present, and or future be construed otherwise. See the UCC Articles 3, 8, and 9. Respondents have allowed the 10 calendar days or 20 calendar days total if request was made by signed written application for the additional 10 calendar days to elapse without providing the requested and necessary proof of claims for which respondents have entered into fault, and the claimant has transmitted a notice of fault and opportunity to cure and contest acceptance to the respondents, wherein respondents were given an additional 3 days, 72 hours, to cure respondents' fault. Respondents failed or otherwise refused to cure respondents' fault, and respondents are found in default, and thereby and therein respondents have established respondents' consent and agreement to the facts contained within the conditional acceptance and counteroffer, as said facts operate in favor of the claimant, that the judgment of alleged court of record within the above referenced alleged commercial civil cause is void ab initio for one of subject matter jurisdiction of said venue. Insufficient document, information, and affidavits in support thereof for one of establishing a claim of debt, one of relationship with the source of authority for said statutes laws, for one of privity of contract, or contract itself, improperly identified parties to said judgment as well as said dispute matter. What's up, little man? I don't got any food. Alright, let's continue and see. Respondents agreed and consented their respondents to do a duty and obligation to claimant, as well as the corporate government, department, agency, constructs, respondents, represents, serves to correct the record in the alleged commercial civil cause, and thereby and therein release the indenture, however term, style, upon the claimant, and cause the claimant to be restored to liberty, and release the claimant's property rights, as well as all property held under a storage contract in the name of the capital letter name defendant within the alleged commercial civil cause, within the alleged commercially bonded warehousing agency, DBA, for the commercial corporate government construct, DBA, the United States. That this arbitration award is to be construed contextually and not otherwise, and that if any portion of the provision contained within this arbitration award, the self-executing, binding, irrevocable contractual agreement coupled with interest, is deemed non-binding, it shall in no way affect any other portion of this arbitration award. That the arbitrator is permitted and allowed to adjust the arbitrator award to no less than 2 times the original value of the properties associated with this agreement, plus the addition of fines, penalties, and other assessments that are deemed reasonable to the arbitrator upon presentment of such claim, supported by prima facie evidence of the claim. The defaulting party will be estopped from maintaining or enforcing the original offer presentment, i.e., the above referenced alleged commercial civil cause, as well as all commercial paper negotiable instruments therein, with any court or administrative tribunal unit within any venue, jurisdiction, and form the claimant may deem appropriate to proceed with in the event of any and all breaches of this contractual agreement by respondents to compel specific performance and or damages arising from injuries therefrom. The defaulting party will be foreclosed by laches and or estoppel from maintaining or enforcing the original offer presentment in any mode or manner whatsoever at any time within any preceding action. Furthermore, the respondents are foreclosed against the enforcement, retaliation, assault, infringement, imprisonment, trespass upon the rights, properties, estate, person, whether legal, natural, or otherwise, of the presenter, petitioner, and or his interest, and or his estate retroactively, at present, post-actively, forever, under circumstances, guise, and or presumption. This thing is really long, but let me see. That's up to page 9 right there. I'm going to switch over and just read a little bit of read a little bit of the summarization of the arbitrator's final award. Okay, so it says, clarification. The original award was referenced to each respondent in respect to treble damages. Therefore, this arbitrator sees fit to provide clarification. It is uniformly settled that a court's right to vacate or modify an arbitration award is extremely limited. That said, many state arbitration statutes, as well the Federal Arbitration Act and the Uniform Arbitration Act, allow correction or modification for an evident miscalculation in the arbitrator's award. See 9 U.S.C. Section 11A. Many state courts have held that an award can be corrected only for miscalculations that appear on the face of the award and for mathematical errors that are patently clear. This arbitrator has been appointed in the above referenced matter on behalf of this arbitration association to settle and resolve any and all disputes arising thereunder by arbitration under the authority of the Federal Arbitration Act. An arbitration hearing was held on July such and such, 2019, at which time the arbitrator reviewed all contractual agreements and documentary evidence submitted by this party in this matter. This arbitrator fully considered and granted the claimant's request for summary disposition and further considered all the evidence in reference to the contract, its terms, promises, and obligations, as well as the facts and support as presented during the arbitration of this controversy. The summarization of this award is based on the arbitrator's need to clarify some pertinent information. On or about May 2nd, 2019, the claimant and respondents entered into a written, irrevocable, binding contractual agreement, which included an arbitration clause. Both parties entered into a legally binding contractual relationship, and this arbitrator found that no fraud in the inducement to contract or fraud in de facto was present. Thus, respondents are bound to the terms and obligations agreed upon and imposed on them. To date, the respondents have failed to respond to the claimant, and this arbitrator has found that the respondents were not willing to participate in the hearing. Therefore, after careful consideration of the evidence presented, this arbitrator finds as follows. This arbitrator finds that the claimants, as well as the respondents, are consenting adults, having attained the age of majority, not a minor, not an infant, not a delinquent, and or a decadent. All parties are fully capable of entering into a negotiation contracts. And I did not find any of the parties to be suffering from any mental disease or defect that would have prevented and or interfered with their knowing and intentional entering into the binding contractual agreement. And the arbitration hearing was held on this date, at which time this arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. This arbitrator fully considered and granted the claimant's request for summary disposition and further considered all the evidence in reference to the contractual agreement. The arbitration hearing was held on this date, at which time this arbitrator reviewed all contractual agreements and documentary evidence submitted by the parties in this matter. This arbitrator finds that the respondents have failed to fully perform to the terms of this agreement and that the claimant is entitled to immediate and unconditional remedy as prescribed within the terms of this contractual agreement. And a prior relationship did exist between the parties, and the respondents had an obligation to respond to the reasonable request of the claimant. And the respondents failed to provide proof that they have not received and or been notified of the existence of the contractual agreement and of their right to waiver. And the respondents failed to respond to the contractual agreement mailed with proof of service by the claimant on this date, which constituted an act of tacit acquiescence. And the respondents have failed to fully perform to the terms of the agreement, and the claimant is entitled to immediate and unconditional remedy as prescribed within the terms of the contractual agreement. And, furthermore, this arbitrator finds that the total amount of recovery for claimants is $27,000 US for compensatory and punitive damages. The respondents have 30 days from receipt of this award to comply with the decision of this arbitrator. In the event that the respondents fail to comply with the decision of this award, this arbitrator may revisit this matter upon request of the claimant and according to the terms and conditions of the contractual agreement to modify this award in an amount equivalent to 2 times the determination of this arbitrator for each respondent. The contract stated that any final and binding arbitration award may be confirmed in any United States District Court, pursuant to Title IX of the United States Code, Section 9 and Section 13. The Supreme Court has explained, there is nothing malleable about must grant, which unequivocally tells courts to grant confirmation in all cases except when one of the prescribed exceptions applies. A judicial review of an arbitrator's award is extremely limited, and the court must accept the arbitrator's credibility determinations even where there is conflicting evidence and room for choice exists. An arbitrator's award should not be vacated for errors of law and fact committed by the arbitrator, and the court should not attempt to mold the award to conform to their sense of justice. Claimant may seek confirmation of this award in a United States District Court. Confirmation of an award is generally a summary proceeding that merely makes confirmation of an award is generally a summary proceeding that merely makes what is already a final arbitration award a judgment of the court. This award is final and binding between the claimant and the respondents. In the above referenced matter, upon issue and execution of this arbitrator's signature below, and full force and effect take place immediately upon issuance. And then we have the seal of the arbitrator, the jurisdiction. So I just want to read a little bit of what to expect once you file your claim. Once you have major counteroffers, have contracted, and once your respondents have defaulted on their duty to respond or perform. All right. So this is evident of how all courts should operate. But as you see, so pay attention, study, and demonstrate. So I've yet to schedule a hearing for this property owner that has filed this eviction on us and got a summary judgment on it. What I have been able to do is get evidence and get on the record of him committing a bunch of more commercial crimes by breach of contract and fraud upon the court, claiming that I owe him when actually he owes us, right? So, at a minimum, I already know that the award should be at a minimum $90,000 for this property owner, and so we're expecting peace and harmony when we go into the clerk's office on Monday to file our papers. At the same time, we're prepared to do battle if there's an enemy at the gate that wants to try to not allow our affidavits to be filed on the record. So, gonna give me a little sun, do a little sunbathing right here by the pool before I go in and write this motion to vacate order, summary judgment, and write up my federal civil suit claims. Because once you, what I believe is, what I think, what I've practiced is, once you can start writing your affidavits by hand, and you keep studying, eventually you can learn to write them from scratch.